So good afternoon, everyone. My name is Tanya Landon from Sidley Austin. I'm very, very pleased to be here today to moderate this YCAP symposium on the mechanics of third-party funding in international arbitration. We have a very distinguished and experienced panel with us here today to talk about what has become actually a very hot topic in international arbitration circles. In fact, this very morning, the Honorable Justice Ian Binney, in his keynote speech to launch the conference, addressed some of the key issues surrounding third-party funding. But before we turn to the heart of the matter, I'd first like to start by briefly introducing our panel members. So to my right, we have Jim Rhodes. Jim Rhodes is an independent arbitrator and mediator based in New York City. He's also a senior advisor to Burford Capital, one of the largest providers of litigation finance in the world. Jim is originally from Texas, started his career with the Antitrust Division of the U.S. Department of Justice. He was a partner with two prominent New York City law firms, focusing his practice on litigation, arbitration, and antitrust matters. Jim is now a solo practitioner and has acted as counsel and arbitrator in dozens of commercial, investment, and securities arbitrations. And he also regularly acts as mediator and consults on ADR and other issues. Jim is admitted to practice in New York and Texas. Beside Jim, we have David Roney. David is a partner in Geneva at Sidley Austin, focusing his practice on international commercial and investment arbitration. He acts as counsel and arbitrator and for various arbitrations under various institutional rules and with seats around the world. He's admitted to practice in Ontario and in England and Wales. Now, David is also a co-founder and executive committee member of the FIA, which is the Foundation for International Arbitration Advocacy, a group that provides training in oral advocacy and examination of witnesses to international arbitration practitioners. Among his many other professional activities, David is a member of the ICC National Committee for Canada, and actually, along with Ian Laird, who's with us here today, was one of the co-founders of YCAP. So it's quite fitting that they're both here today on this panel. Now turning to Ian. Ian Laird is a partner in the International Dispute Resolution Group of Crowell and Mooring, based in their Washington, D.C. office. He's admitted to practice in Ontario, as well as a special legal consultant in the District of Columbia. Ian has been counsel to parties in investment arbitrations for over 13 years and has been involved in the earliest NAFTA investor state arbitrations involving all three NAFTA state parties. Ian also has significant government experience in Canada and was the Chief of Staff to the Minister of Citizenship and Immigration between 2003 and 2004. Ian is also well known for his website, investmentclaims.com, and he currently lectures at Columbia Law School, teaching a seminar on international investment arbitration. And as for me, as Monica mentioned, I am an associate at Sidley Austin's office in Geneva, Switzerland. I specialize in international commercial arbitration. I've acted as counsel and tribunal secretary in a number of arbitration proceedings under some of the major institutional rules. I got my law degrees from McGill University in common and civil law, and I am admitted to practice in New York. So just by way of introduction, to go back to why we're here, this party has been asked to focus on the mechanics of third-party funding in international arbitration. As I mentioned, this is actually a pretty hot topic on the arbitration and arbitration circles. So why is third-party funding attracting so much interest? How prevalent is it in arbitration? It's actually hard to know, because due to the private nature of arbitration, there's little empirical data to show the extent of third-party funding in arbitration right now. But based on anecdotal evidence, it seems that third-party funding is on the rise. So I want to start with giving you a very brief introduction to the topic. We'll provide some initial answers to some pretty basic questions about third-party funding. And then I'm going to pass the torch to Jim, David, and Ian, who will share with us their knowledge and experience and really delve much deeper into the issues. And then of course, we'll have some time, hopefully, for a Q&A at the end. So let's start really at the very beginning, the most basic question: what is third-party funding? So it can be defined. There's no one definition, but we could use the following definition: an arrangement whereby a party to legal proceedings receives funding for some or all of its legal fees and expenses from an unrelated third party. And let's call that third party the funder. So in exchange for the funding, the funder usually receives an agreed share of any damages award or settlement. This could be in the form of a percentage of the award and or a success fee. If the funded party is unsuccessful in the action, the funder would then receive no reimbursement for the investment and actually may have to bear some of the costs of the proceeding. Now, who are the players in third-party funding? Who are the recipients of it? Most commonly, the recipients are claimants or potentially respondents bringing counterclaims. It's much more rare to have a respondent receiving third-party funding. Typically, you have claimants who are in financial distress. They don't have the financial resources to pursue their claim, even if they have what they believe is a strong claim. But there could also be companies who may have the financial resources to pursue claims, but want to outsource their legal costs, or maybe they want to manage cash flow or risk, and so they may be interested in turning to a third-party funder for their claims. Now, on the other side of the deal are the funders. And we know that there are a growing number of specialized providers of litigation finance. These can be public or private companies or private funds. Now, one key point that I expect will come up in the presentations today is that the funder is obviously not a party to the underlying arbitration agreement. So they're not a party to the arbitration once it gets going. So this then leads to the question of the role that the funder should play in the arbitration proceeding. This question has generated a lot of controversy, and I think we'll see some of the reasons why that's the case today. So why is third-party funding generating such interest? Why is it so controversial? I think part of the reason is that there are a number of perceived risks and benefits associated with third-party funding. And to make matters even more complicated, what some may consider to be benefits of third-party funding may actually be considered risks by others. So what are some of these perceived benefits and risks? Well, frequently cited is the idea of improving access to justice and leveling the playing field between a party with limited financial resources and perhaps an opponent with very deep pockets. Another benefit might be controlling arbitration costs for parties and spreading economic risks involved with litigation. Yet another idea is filtering out frivolous and unmeritorious claims. Now, some actually might put this one in the risk category and say that having third-party funders involved in arbitration might actually facilitate access to arbitration for claims that should not be in arbitration, that have no merit. So this is one of the controversial aspects of third-party funding. Looking at other potential risks, and we're going to hear more about this today with our presentations, there are potential for conflicts of interest, arbitrator conflicts, or conflicts between the party and the funder. There's a risk of satellite arguments being raised by a respondent if the funding arrangement is disclosed, and those arguments may detract from or disrupt arbitration proceedings. You then have the risk of breaching the confidentiality of the arbitration, given the presence now of some third party who was not party to the arbitration agreement. Another risk is the very real risk of waiving privilege over documents if they're shared with third-party funder as part of a due diligence exercise or as part of the ongoing reporting to the funder about the arbitration. There are many other risks. It could be risk of more frequent applications by respondents for security of costs if they find out that a third-party funder is actually funding the claimant to a claim. And then there's the issue of whether third-party funding should have an impact on cost awards and whether tribunals have the power to issue a cost award against a third-party funder. So these are some of the perceived risks and benefits. But actually today, let's go back to basics. How does third-party funding actually work in practice? So to let you know where we're going today, a roadmap for today's session, Jim will start. He's going to address the business aspects of third-party funding from the funder's perspective. And he will cover such issues as risk evaluation, price, and assessing claims. Then David Roney will continue. He's going to look at some of the key issues for counsel in relation to the funding agreement. So these are many of the potential risks that I mentioned earlier: privilege, waiver, confidentiality, disclosure, and conflicts. And then Ian will address third-party funding issues, in particular relating to investment arbitration. And then he'll also look at some of the common counsel fee arrangements that take place in a funding arrangement. So I would like to now hand over the floor to Jim and then to our other speakers. I would just repeat that you should really take advantage of the presence today of these exceptional speakers, and I would encourage you to ask questions at the end of our session.